Hello, everyone. We're going to get our afternoon session started once Helen sneaks down the stairs. Welcome back to the conference, Truth, Trials, and Memory. And it's my pleasure to introduce Jennifer Prestholt, who's the Deputy Director of the Advocates for Human Rights, who will be chairing this panel, and I will turn it over to her.
Good afternoon. Make sure this is on. Good afternoon and welcome to what I think will be a really exciting discussion. I'm very pleased to be able to be part of this conference and congratulate Barb and everyone involved on what a spectacular conference this is turning out to be. As Barb mentioned, I'm Jennifer Prestholt from the Advocates for Human Rights. We're an international human rights organization that is based here in Minneapolis, but we do work internationally as well and have worked on transitional justice issues since the early 2000s, having worked in Peru and Sierra Leone, and then directly with the Liberian Truth and Reconciliation Commission under a memorandum of understanding. We carried out their work in the diaspora, which was 8 cities in the U.S., 2 in the U.K., and in a refugee camp in Ghana that was then home to 30,000 Liberian refugees. And then most recently, we have been revisiting some of the advocates' early work with the Cambodian community here. In 1990, the Cambodian community, in conjunction with my organization, held a mock war crimes tribunal. And at the time, there was no thought that there would ever be a war crimes tribunal in Cambodia. Many years later, the Extraordinary Chambers of the Court of Cambodia was set up, and so there is now a criminal tribunal. And they reached out to us in the early part of this year and asked us to contact the individuals who had participated in that mock war crimes tribunal. And so those individuals and some others here in Minnesota in the Cambodian community had the opportunity to submit their testimony to the real war crimes tribunal many years later. So all of this relates to the conference today and particularly to this panel because all of my experience in working in this area has changed my thoughts about truth and the value of giving victims the opportunity to share their own truths and their own experiences. So I look very forward to hearing from our panelists. What we'll do today is I'll do a very brief introduction, and I want to save as much time to hear from the panelists as possible. So I encourage you to read their incredible and impressive biographies that are in the materials today. So instead of reading them to you, I will cede that time to the panelists to share their thoughts, but I would like to introduce you to Juan Mendez, who is a law professor at American University and a commissioner on the International Commission of Jurists and many other things. I'd also like to introduce you to Helen Mack, who is here on behalf of the Mack Foundation, the Myrna Mack Foundation, which she started after, unfortunately, losing her own sister and seeing the need for research and documentation of human rights abuses. And then Lee Payne, who is a professor at Oxford University and just flown in from Oxford last night, but who also holds a position here at the University of Minnesota. So what we'll do is we'll have each of our panelists speak for 15 minutes, and then we will open the floor to questions from the audience and have further discussion. So please, Professor Mendez.
Thank you very much. First, thank you very much to the organizers for giving me the honor of participating in this event, particularly the privilege of sharing the panel with Helen and with Lee. I especially want to thank Barb and Paula for thinking of me for this event and congratulate you on this brilliant idea. I am less sure that I should be grateful for putting me up after the panels of this morning, because those are difficult acts to follow. But nevertheless, I want to stress that the morning has shown us that all conflicts, including conflicts in neighboring countries, are different. They are significant in their own right, in their own context. Not only all conflicts are unique, but all transitions are unique as well, and all forms of conflict resolution are unique. And nevertheless, all of them, and especially these two, yield very significant lessons that can be learned and can be applied, mutatis mutandi, of course, in different contexts and different conflicts as well. One important lesson that El Salvador and Guatemala present is that it is possible for the international community to cooperate in the search for peace and in the search for justice, and that one does not have to yield to the other. In fact, of the international community's interventions in conflicts, these are the early ones in which this idea that the whole country has a legitimate expectation for peace, but the victims also have a very legitimate expectation and right to see justice done, has become a model that unfortunately not always has been followed in more recent conflicts. I think the Guatemalan peace accords benefited from the experience of El Salvador that had happened only a few years earlier, but also of trends in Latin America, particularly beginning in the Southern Cone, about what states owe to the victims of very serious human rights violations, what societies owe to themselves when confronted with legacies of very serious human rights violations. So in the case of Guatemala, the UN played an important mediating and facilitating role, perhaps not only by brokering a peace agreement under these principles that I mentioned a minute ago, but also for deploying and engaging a civilian presence to make peace possible first, and then to guarantee as much as possible that the post-conflict situation would respect those agreements. In that context, it generated a UN doctrine about peace and justice that was reflected, for example, in the 1999 guidelines for mediators that the UN adopted. Unfortunately, a document that, although has been ratified a couple of times in 2005 and later under Ban Ki-moon as well, it has never been published. Nevertheless, it is a document that says that the UN mediators cannot accept transactions in the pursuit of peace that can sacrifice some important principles of international law. And even more important, and this is a published document, the doctrine is reflected in the 2004 report of the Secretary General called Rule of Law and Transitional Justice in Conflict and Post-Conflict Situations, that elaborates on all of these principles that we now call transitional justice, but also establishes that the United Nations will help societies that want in good faith to abide by these principles and participate in them. We know that the so-called Historical Clarification Commission, whatever euphemism was used, did act as a veritable truth commission in the best sense of the word, in the sense that it produced much more truth about what had really happened than what we knew before its installation, but also that it created a process that has been repeated elsewhere, by which the most important thing is to hear the victims, to let them tell the story, and for the report to reflect. I think what distinguished the Truth Commission in Guatemala was some of the methodological aspects that were discussed by Professor Tom Mushat and Mrs. Coti earlier today. By this I mean that the process itself benefited from a really strong deployment of investigators and interviewers throughout the country and even in the most remote areas of Guatemala, instead of just opening an office and letting people come up if they want to tell their stories. Again, this is one of those hallmarks of what we now consider the best practices about truth commissions. And the other important characteristic of the Truth Commission, this is of the report, is that it dared to call genocidal acts by their name. We already heard how complicated that was and how fraught with political pressure that is. But the most important thing is not only that the commissioners decided to use the proper name for what had really happened, but two things. One, they did it on the basis of very, very serious and good evidence gathered extensively throughout the countryside. And second, they did so with a very rigorous legal analysis of what constitutes genocide under international law and how the fact patterns in Guatemala clearly fitted that definition. I would also like to mention that the process itself of the Guatemalan Truth Commission benefited from an extraordinary civil society effort that was also mentioned today, the REMI project, the Recuperation of Historical Memory project, that was directed by the Catholic Church, that also meant gathering archives from very remote parishes where people had told their stories, and for years these stories had remained in files that very few people read, but that anybody who wanted to walk in and ask a priest whether they had some stories about it could learn. The fact that this effort cost the life of Monsignor Gerardi is also something that we should bear in mind today as we try to get lessons learned from the Guatemalan process. And a very significant aspect of the Guatemalan peace process was that the amnesty law that was agreed upon in the peace process and as enacted immediately at the end of 1996 is the first amnesty law in Latin America that complies with international law because it excludes certain crimes from the benefits of amnesty. We knew then, and we unfortunately, the events have confirmed that that's not enough to have justice, but it is the removal of an obstacle that at least in Latin America and certainly in Guatemala, because there had been amnesties at every, a couple of amnesties each year, even during so-called democratic governments, every time that there was a revelation of an event, there was almost an immediate blanket amnesty. And in this process, Guatemala shows the trend towards the rest of the world that some crimes are just so egregious that they cannot go unpunished. And the law has to reflect that. And it did. Obviously, the process has had and still has limitations. I don't have to tell you that there is a justice deficit in Guatemala. That almost sounds like a euphemism. but there are efforts, and they were highlighted today. The fact that there was a trial and a conviction of General Rios Mon for genocide is a significant achievement, even if it all came to naught by some far-fetched formalistic legal interpretation. The word technicality doesn't even begin to tell the story about it. But the case is not closed. The case has been reopened. And as we heard also this morning, there are several other cases like that where very brave fiscalas, as you call them, and judges are leading the charge and opening the doors of courthouses to see justice done for the victims. In the truth-seeking and truth-telling area, which is really the subject of today, I think we need to remember that this obligation of the state to tell the truth is not satisfied only with a truth report. It is an ongoing responsibility of the state to keep digging and keep finding the evidence of what happened. Like our friend Jose Salaquet has said, it's important to give each family an individualized truth. It's also important to give a social truth to the nation. But it's very important to consider this a right to the truth by the families. And in that sense, there's lots to be done. There's lots of fate and whereabouts of the disappeared still to be established, and particularly a lot to determine about who gave the orders, who complied with them, who used the power of their offices to shield accomplices from investigations, etc. Until all of that is established, the obligation in Guatemala will still be there, and it will be up to the civilian society to continue pressing for it. There's also the need to follow up on recommendations of the Committee of Historical Clarifications. I don't know if an effort has been made, but whenever there's a Truth Commission reports, there are numbers of recommendations, and it's important to go back to each one of them and determine what's the status of implementation of those recommendations. And in the area of disappearances, I already mentioned the encouraging developments that we have, but they're only encouraging. They're not fruitful yet, and it's important for all of us in the international community, and especially for Guatemalan civil society, to give the political and moral support that these efforts deserve if they are going to succeed. I draw some encouragement from the fact that despite the attempt of President Morales, CICIG is still there. CICIG is there, and it's creating some kind of bulwark, at least, against the efforts at impunity, impunity for past crimes, but also impunity for corruption now, impunity for current crimes, I would say as well. Yes, thank you. I just want to finish by drawing a couple of conclusions, drawing us back to what we call transitional justice, that is both a societal effort and practices that are shared among nations, but also a set of obligations by the state, a normative framework now clearly established as part of international human rights law that demands from the state certain behaviors. So first, those behaviors have to do, as we know, with truth, with justice, with reparations, and with measures of non-repetition, or what we sometimes call institutional reform. In all of those areas, there's a lot for Guatemala to still do. It's important that the four obligations have to be articulated, that there should be cooperation between each of them, that the Truth Commission reports should be followed up, for example, with reparations, but also with prosecutions, and that the measures of non-repetition should draw, the measures should be drawn from the lessons learned in the process of truth-seeking and truth-telling. The worth or the assessment of the relative success or failure of a Truth Commission has to be first the process, and in this case, the Truth Commission of Guatemala is a stellar success. And do we know more at the end of the process than we did before? And again here, this truth report passes that test with flying colors. I would also mention that reconciliation has to be understood as transformation. I think this morning, I think Doug Castle said that it's not enough just to go back to the way things were before the conflict. We need to transform the society. And in that sense, we cannot just consider a society reconciled unless we make an effort to transform it in the sense of providing for more inclusion, less difference in treatment, and particularly much less discrimination of all sorts. And my final point is that all of this requires understanding of the measures of non-repetition as being centered around memory. It is memory that will allow us to transform. It is memory that will make us know what to do with the product of a Truth Commission, of prosecutions, etc. And I think Guatemala is another example, and not the least one, where the desires for justice live on no matter what the obstacles that are presented on its way. And in that sense, it is memory of what happened in Guatemala that will be the best way to move forward in the transformation of the society on the basis of what we've learned about this conflict and its tragic consequences. Thank you very much. I'm sorry.
Thank you very much. And you might notice that there are people coming around with cards. We encourage questions, so please write your questions on the card and you can pass them to the end of the aisle. Helen, please share with us your thoughts.
Sí, yo no sé, bueno, una presentación, pero no sé si está ahí. Bueno. That's fine. Bueno, como se ha dicho, voy a dar un testimonio prácticamente personal, pero que a lo largo de la experiencia de muchas víctimas y familias de víctimas en esta búsqueda de la justicia, hemos coincidido, diría yo, que no necesariamente toda la verdad y toda la justicia se convierte en un tema legal. Y por lo tanto, no necesariamente toda la parte teórica es lo que realmente sucede en una realidad. Entonces, en el caso, por ejemplo, cuando mataron a Mirna, nosotros solo sentimos o se sentía la pérdida violenta, brutal e inesperada, y nos sentimos golpeados duramente por el sufrimiento y el desasosiego. Fue en los días subsiguientes cuando empezaron a emerger preguntas como ¿por qué la asesinaron y quiénes eran los responsables? Poco a poco nos adentramos en un mundo desconocido en pos de respuestas y dimos los primeros pasos por una senda en las que no hay vías de retorno, que es la búsqueda de la verdad y la justicia. Y digo que no hay vías de retorno porque tras ser afectado por un hecho de esta magnitud, nunca se regresa al punto de inicio. Uno no vuelve a ser el mismo luego de haber sido golpeado por comportamientos barbáricos e irracionales, en especial cuando el aparato estatal monta confabulaciones para encubrir y mantener impune un hecho que en principio fue perpetrado a instancias suyas. Además, la búsqueda de la justicia puede ser edificante o perversa, o ambas cosas de manera simultánea. Es perversa cuando el proceso se trunca por miedo, por cansancio o hartazgo de enfrentar sistemas de justicia y regímenes políticos que de manera corporativa utilizan la violencia y mecanismos de diversa índole para ocultar su responsabilidad, obstruir el avance de los casos, desalentar a los familiares de las víctimas y proteger a los criminales. La acción de quien busca esclarecer una violación de los derechos humanos se convierte entonces en fuente de frustración y rabia, o de conformismo o indiferencia. Todas ellas emociones enfermizas que operan en sentido negativo contra uno mismo y contra la sociedad de la cual se es parte. Si uno sigue adelante y obtiene justicia, aunque sea en un grado relativamente satisfactorio, la experiencia puede ser traumática, por lo que implica afrontar el embate de los mecanismos de obstrucción, de violencia, de corrupción y los diversos tipos de encubrimiento que configuran sólidos patrones de impunidad. Uno enfrenta comportamientos definidos por la confrontación ideológica, la conjugación de intereses espurios y el dominio de factores culturales que motivan a los operadores de justicia y a las instituciones a traicionar los fundamentos éticos de su profesión y los altos valores de la justicia. Ahí es donde radica el componente perverso. El factor edificante que se contrapone a la perversidad del sistema depende de nuestra capacidad de asimilar las vicisitudes que hallamos en la búsqueda de la justicia. A fin de cuentas, cada paso que damos, cada obstáculo que superamos, conforman experiencias plenas de aprendizaje que nos cambian la vida y nos enseñan a evaluar nuestro entorno político y social con ojos más escrutadores, exigentes y críticos. Puedo clasificar mi relación con la justicia como una mezcla de vivencias perversas y constructivas. Y he optado por extraer lecciones del conjunto de vivencias, tanto de lo positivo como de lo frustrante. Los procesos judiciales nacionales e internacionales que impulsamos para esclarecer y sancionar la ejecución extrajudicial de mi hermana han capturado desde entonces mi vida un lapso prolongado en el cual aprendí a conocer muy de cerca la impunidad y las características del sistema político que la cobija, la alimenta y la hace crecer. Cuando se logra traspasar el ámbito personal y se cobra conciencia de que es posible luchar contra la impunidad a través del impulso tenaz de la búsqueda de la justicia, se empieza a creer en la posibilidad de tejer procesos de lucha contra la impunidad que aseguren, por un lado, un no retorno al pasado de violencia irracional a cuenta del Estado, y por el otro, que garanticen la deducción de responsabilidades a personas e instituciones que han cometido graves crímenes. Realmente se concibe la esperanza de transformar radicalmente la situación, especialmente en sociedades donde se viven periodos de posconflicto, procesos de democratización y dinámicas orientadas a erigir sistemas políticos que sustituyan a esos modelos dictatoriales y autoritarios. Con esa motivación, uno apuesta al sistema de justicia nacional, pues es ahí donde pueden gestarse las transformaciones que harían posible derrotar el patrón de la impunidad. Pero no es fácil. Es casi imposible cuando el Estado ha sido diseñado para preservar los intereses de las élites político-militares y económicas dominantes, y que han sustentado sobre la base de la corrupción, exclusión, discriminación y violencia. De tal forma que el aparato estatal se convierte en un instrumento para preservar esas prebendas y propician ese régimen de impunidad con una marcada ausencia de espacios para la toma de decisiones y una sistemática denegación de justicia. Ya hoy en la mañana escuchamos todas las conclusiones de 200,000 muertos, 45,000 desaparecidos, y en una recomendación sobre el sistema de justicia, la Comisión de Esclarecimiento Histórico llega y dice: el organismo judicial, el Poder Judicial, fue responsable por acción o por omisión de las acciones de violaciones a los derechos humanos. Aún así, las víctimas vamos siempre en esa búsqueda, porque es una búsqueda natural. Y después, el caso de Mirna, en el caso dijéramos, de justicia, yo quisiera como que hubo dos periodos. Un primer periodo que es antes de la firma del Acuerdo Global de Derechos Humanos, que es en el año 94. Y el caso de Mirna es el primer caso de justicia ante, dijéramos, en el marco del conflicto armado interno en el sistema de justicia que se presenta. Ahí, bueno, en ese entonces el profesor Tomuchat era el experto de derechos humanos en Guatemala. Llegó un día después del asesinato de Mirna y, bueno, mi historia era que no conocía nada de derechos humanos. Y ahí empiezo a enterarme un poco de lo que esto es y con la, diría, ingenuidad de una persona de clase media, urbana, no involucrada en temas de derechos humanos ni de política, me voy al sistema de justicia y empezamos a confrontar que eso que te dicen no es cierto. Y yo sabía que cada vez que llegaba el profesor Tomuchat, que llegaba a la Comisión Interamericana, que llegara a cualquier delegación, inmediatamente éramos sujetos de amenazas e intimidaciones. Ese primer caso, por ser el primer caso, el atrevimiento de estar exigiendo justicia, estar acusando al ejército, nos hizo establecer una estrategia que fue apoyada mucho con académicos de las distintas universidades de Estados Unidos, fundamentalmente en Berkeley. Una estrategia, también otra base que se hacía sobre el tema de una estrategia política, que también comunicaba lo internacional con lo nacional, porque decía, los sistemas internacionales lo ves muy lejano, es una justicia, primero no estás acostumbrada al lenguaje jurídico, y luego si es interamericano, que tiene, por ejemplo, en este caso que era la Comisión Interamericana, una importancia, tenía que ser una estrategia complementaria. Ahí sí, pues eso, era de complementariedad. Y ese primer caso hizo que vinieran otros casos después. Entonces escogimos, bueno, ahí con parte de la estrategia, 2 casos nacionales y 2 casos internacionales. El primer caso era el caso de Mirna y la masacre de Santiago Atitlán, que ahí lo ponemos. Y luego el caso de Michael Devine, que era un ciudadano norteamericano, y el caso de la monja ursulina Diana Ortiz, que se había llevado a cabo en el año 89. De esos 4 casos, el caso de Michael Devine, que por ser un ciudadano norteamericano logró la condena del primer oficial, a nivel de oficial, y antes de que se le notificara la sentencia, le dieron la fuga. Y luego el caso de Mirna fue en el año 93, que estábamos en el marco también de las reformas al sistema judicial. Juntamente con esto y con la firma del Acuerdo Global de Derechos Humanos, lo que empieza es un retroceso en los subsiguientes casos de derechos humanos, porque lo que se esperaba era la amnistía. Después de haber firmado el Acuerdo Global que establece la Comisión de Esclarecimiento Histórico, entonces los casos de derechos humanos comienzan a tener un retroceso y empezar toda la obstrucción de justicia, y el argumento era el cambio del sistema judicial. Las violaciones a los derechos humanos continúan, y el otro punto que marca, dijéramos, la historia en el tema de la justicia es el asesinato de Monseñor Gerardi. Y es hasta en el año 2001, siempre a nivel de autores materiales, se logra la primera condena también a nivel de capitán, que es el capitán Byron Lima, y se deja abierto el procedimiento. Y para mientras el caso de Mirna, que hasta el día de hoy es el único con autoría mediata, con autoría intelectual hacia un general, se comienza. Vienen el resto de los casos que, en resumen, hoy por hoy, hay muchos más, pero yo podría decir que son 6 casos por desapariciones forzadas, que los podemos ver ahí. Creo que el primer caso fue el caso de Chuatalún, que era a nivel de comisionados militares o patrulleros civiles. Y son 4 ejecuciones extrajudiciales. 2 de ellas se han basado mucho sobre el tema del archivo histórico de la Policía Nacional. 2 masacres, el caso de genocidio y el caso de Sepur Zarco. Muchos de esos casos, como se dijo hoy en la mañana, estos están dijéramos, como casos ilustrativos de la Comisión de Esclarecimiento Histórico, pero aquí la importancia es cómo las víctimas, a pesar de que han transcurrido 34 años, su deseo por esa búsqueda de la verdad y de la justicia, han empujado estos casos. Y hoy también tenemos, pues, 2 casos que son importantes. El caso de Creompás, que es también muchas ejecuciones extrajudiciales, que sale de una masacre, que es la masacre de Río Negro, sale el caso de Creumpas y luego el caso de Molina Thyssen, que sí lleva, yo diría por su importancia, que es la inteligencia del ejército, una de las estructuras más importantes y temibles, que es la del caso de Molina Thyssen. Yo diría que esto está todavía en proceso, pero hemos visto nuevamente cómo esa impunidad del pasado es la impunidad del presente, y por eso las organizaciones de derechos humanos ya en el 2000, yo todavía recuerdo cuando Juan, sí, era Juan, llegaste tú primero a contarnos un poco la creación del ICTJ, y después al mismo tiempo estábamos con el Grupo Conjunto del Salvador, ahí ya empezábamos a cranear algo similar que podía ser para Guatemala, lo que ya en el año 2000 con las organizaciones empezamos a discutir lo que era la CICIAX. Pero después éramos testigos de esa transformación de estas escuadrones de la muerte, de estas redes de impunidad, que son estructuras básicamente del ejército, pero confabulados con el sistema político, el sistema económico. Siempre es procesos que nunca logran concluir, y solo para hacer en la historia contemporánea, Guatemala no termina sus procesos porque no hay interés. El Estado está diseñado para que nada cambie. Entonces, tenemos la revolución del 44, la contrarrevolución en el 54, en el 64, la caída de Diego Fuentes, después está en el año 64, 74, 84, primero es el 82 con Ríos Montt, después viene el 84, viene el 94, se viene el proceso de paz, se firma la paz, y 20 años después estamos otra vez en la misma crisis, volviendo otra vez a lo que la Comisión de Esclarecimiento Histórico termina diciendo: esto fue el origen del conflicto. Y lo que es peor son que hoy nuestros indicadores de desarrollo social, económico, sobre todo nuestros DESC, son peores que cuando se da el origen. Entonces, la pregunta que uno se hace es, bueno, ¿la justicia transicional realmente logra y contribuye a lo que queremos y logra transformar a las sociedades? A pesar de que hemos tenido discusiones, ¿te recuerdas, Juan, cuando hablábamos que tenía mucho todo este argumento del concepto religioso de verdad, justicia, perdón y reconciliación? Hicimos en relajo, vinieron la revisión de los principios de Joannet, y entonces precisamente fue verdad, justicia, garantías de no repetición. Pero ¿en qué momento se vincula las recomendaciones de la Comisión de Esclarecimiento Histórico o de las Comisiones de la Verdad con el origen del conflicto para transformar a esas sociedades o transformar el país? Si siempre va a depender pues de una narrativa que te quieren imponer los victoriosos del conflicto armado, o simple y sencillamente de un poder que no quiere cambiar, o que si los procesos de paz se llevan a cabo simple y sencillamente porque son beneficiosos económicamente. Y digo beneficiosos económicamente porque en los últimos procesos de paz lo que te hacen es cambiarte el modelo económico, y sin sentirlo te van cambiando de un modelo a otro, en donde lo que hay es más exclusión, más marginalización y más discriminación. Yo lo dejo ahí, después hablamos cómo en la discusión del instrumento de CICIG, en un primer momento sí lo vimos como un instrumento de justicia transicional, porque se basaba sobre el sujeto activo, CICIAX, pasivo, y luego con la CICIG, por la experiencia que habíamos tenido en toda esta discusión de un Estado que no quiere cambiar, pues ya se hizo énfasis en todo lo que fue el sujeto activo, y cómo ha sido más satisfactorio y se ha podido entender un modelo de Estado a través de estos casos de corrupción, que no puedes hablar de justicia transicional en corrupción, pero que esa impunidad del pasado es la impunidad del presente, en donde los actores son exactamente los mismos. Yo lo dejaría ahí para este debate.
Great, thank you. Lee.
Well, thank you for holding up into the afternoon. Maybe the freezing temperatures will keep us all awake for the next couple of sessions. I wanted to thank the organizers, especially Barb and Paula, but also Rochelle and Marina, for all the work you put into this. It's really turned out to be a fabulous event, and I'm sure will continue to be so, so thank you very much. And I also wanted to say what an honor it is to be on this panel with Jennifer, our moderator, but also with Juan, who I've known for a long time, but have admired, and Helen, who I'm meeting for the first time, but who have admired her work as the symbol of civil society and their action, unfortunately, based on victimization, but it's still very important action in terms of bringing about justice. Barb started the session off yesterday talking about reconsidering the processes in light of what we know now and what truth was told. And I'm going to pick up those couple of themes in my accounting of the Guatemalan Truth Commission, but I'm going to talk about a kind of truth that was told, that wasn't part of the official truth, wasn't maybe meant to be told. But before I do that, I want to say a little bit about what, in light of what we know now, how our truth commissions assessed. And many of you know that I've worked on quantitative studies of the impact of truth commissions and also trials and amnesty laws. And what we found in our statistical analysis is that truth commissions aren't statistically significant when it comes to reducing human rights violations and strengthening democracy. Maybe they were never intended to be that. That's not necessarily the goal. But in order to study whether transitional justice works, the question that Helen left us with at the end, this truth commissions haven't proven to help in these two goals. Our first study showed that they were actually negative for human rights, but in updating that study and including more time and also more truth commissions, we're not saying that they're negative for, we're not finding that they're negative for human rights violations, but they're still not having that positive effect. What they have, what we do argue is they still play a role, and particularly in exposing the truth about the past, of constructing an official narrative, even when that narrative is often contested. And it also attempts to address victims' needs for the basic rights of truth, justice, at least restorative justice, reparations when it's in the recommendations, which is not always the case. But we're not sure that they get to this institutional reform, even when it is in the recommendations, as Juan mentioned in his presentation, and therefore limited in terms of guarantees of non-recurrence. Part of the reason, and I think this gets back to some of the presentations we've already had today, is the failure to get at these root causes of the violence, and particularly deeply embedded systems of inequalities. So what we've started to do is to try and look at whether there's some part of transitional justice that can, using the standard mechanisms of transitional justice, truth commissions, and trials in particular, whether there is a way to get at these root causes. And so we began a project on what we're calling corporate accountability and transitional justice. And by corporate, we really mean economic actors, individual economic actors, business associations, and businesses, domestic as well as multinational. We defined corporate complicity, or the economic actors' complicity, in these four ways: joint criminal enterprise, during dictatorships and armed conflict. So this includes, in our database, on-site detention centers. It also includes involvement of certain economic actors in the disappearance, murder, torture, and it includes land grabs. We also include financing human rights violations, and this could be the role of banks in sanction busting, but it also is the funding of death squads, which we can talk about later. And we look at labor violations, the slave labor in particular, as well as the engagement of illegal enterprises that are based on violent kinds of forms of trade, like drug trafficking or conflict minerals, the blood diamonds case. So we started this project not really expecting to find a whole lot in traditional transitional justice mechanisms, but you can see here what we did find. From the very beginning of transitional justice, with the attempts at accountability for violations during the Holocaust, we found over 300 companies and also individual business people involved in those violations, meaning judicial action was brought against them in some form. I'm not going to go into all of the details about that. It would be too long for my 15 minutes. I'm going to focus on the Truth Commission's cases. As you see, we also have over 300 companies that have been named in Truth Commissions. We also look at judicial actions. We have 138, and we keep finding more. I just found some yesterday on the plane ride here. So we have to constantly update those judicial actions, again, for businesses or individuals who were involved in human rights violations during dictatorships and in armed conflict. And we've also done some analysis of the justice and peace cases in Colombia, meaning the paramilitaries that were put on trial, and in the judge's decision on these cases, they mention businesses that they were working with in carrying out human rights violations. And we have over 400 of those cases. You can ask me about any of those in the Q&A or during our break, but I wanted to focus on the Truth Commissions today. As I mentioned, we have over 300 economic actors that were named in Truth Commissions. This is interesting because very few of the Truth Commissions, in fact, we've only found one, the Liberian one, that actually has in their mandate the look for corporate complicity in the human rights violations. There's some that include economic crimes without necessarily having any human rights violations, and we only count the ones in which they're linked. They could be in economic crimes and human rights violation, but they have to have that human rights violation to be included in our database. Despite not having this in the mandate of Truth Commissions, over half of the Truth Commissions have not only mentioned the role of businesses in the violations, but have named names of companies. So that's why we have 300 economic actors who are named. I've listed the Truth Commissions that have these, that have named names, and I have one question about El Salvador because we haven't been able to find a searchable file. If anybody has one of the Truth Commission report, please send it to us. But what I did use was the National Security Archive naming of the Miami Six. And I've been searching for their names, and I have been finding a few of those. So I think we're going to add El Salvador to this list of Truth Commissions. The important thing to mention here about Guatemala is that it had the second highest number of companies named in the Truth Commission. But nobody knows that, right? I mean, very few people would say, Guatemala, they've gone after businesses that were involved in the violence. The highest number is Brazil with 123, and the second highest is Guatemala with 45 companies or individuals named. After that, it's Liberia with 34 and South Africa with 30. These cases are mainly companies and some individuals and business associations. They're mainly national companies rather than multinationals or subsidiaries of multinationals. They're primarily in agriculture, rural farms in particular, and they mainly involve direct action, meaning arbitrary detention, extradition, killing, homicide, torture, kidnapping, and enforced disappearance. But there's also a role for financing that repression in more indirect action. The bulk of the victims are workers. When we could tell that they were unionized, we have about 29% of unionized. We put as non-unionized if it wasn't identified. The other thing that's important to say, though, is that there are no recommendations regarding looking at this, maybe not a phenomenon, at this problem of concentration of wealth in the country and the role that economic actors played in the violence. That's not surprising. Most Truth Commissions did not include recommendations. The Brazilian one, three, the Brazilian, the Liberian, and the Ecuadorian Truth Commissions called for further investigation to determine if there were criminal acts. But most either had very vague recommendations about improving institutions with a human rights objective, including businesses, and the South African one that calls for voluntary reparations by businesses. The others didn't include anything. These are the companies and the individual actors that were named, the 45 that we have. I should also say that Guatemala has had very little follow-up in terms of those companies named, not necessarily rare for what we're finding in the truth commissions. There are 5 cases that have been brought where there's been some kind of judicial action. So far, no decisions. There's the one case that's pending is the Alien Torts Claim Act against the Coca-Cola subsidiary, and the 2 national firms. One is a state firm in electricity, the INDE, and then Zimeri is another textile and gun manufacturing company that's been brought up on trial, but they haven't advanced through the system yet. So in this sense, Guatemala, you could say, I think this gets back to Helen's point, is, yeah, there's some positives in terms of naming this responsibility, even maybe the beginnings of some judicial action, but very little has been done. And Guatemala could be said, even though it's one of the highest in terms of truth commissions, in terms of judicial action, Latin America as a whole is a protagonist in taking some of these companies to court for their judicial action, but Guatemala doesn't meet the highest cases in terms of doing that. Argentina is the highest in terms of bringing judicial action. Colombia follows second, but Colombia has more convictions, and so it shows up in this one in terms of outcome. You'll also see that most of these cases in the Americas have been brought in domestic courts, whereas in other regions of the world, they're mainly in foreign courts. We only found one international case, which is the Rwandan media case in the ICTR. Okay. The other thing that's interesting about Latin America and where Guatemala does fit is this high number of pending cases. Even though the pending case in Guatemala is in a foreign court, in the U.S. courts, this notion that the only region with pending cases that we've been able to find is the Americas, which means there is increasing interest in thinking about how to hold these companies responsible for the role that they played in the past violence. Okay, so what do we make of this? We have developed a framework looking at these cases that there are 2 important factors in terms of holding companies accountable for human rights violations, either in truth commissions or in trials. In other words, the explanation holds for both. One is that there have to be institutional innovators. In truth commissions, because there's no mandate for holding businesses accountable, we need the institutional innovators who are hearing the testimony of individuals and then incorporating this into the final report for them to appear. Without those institutional innovators, commissioners who would just do what the mandate says, these might not appear at all. And in courts, this is even more importantly because there isn't an established international law that can be drawn on, and so the kind of institutional innovation that we're finding taking place in the domestic courts, and again in Latin America, have been the blending of international human rights law and standard domestic law, like labor law or money laundering law, in which they can avoid statute of limitations requirements because of a crime against humanity. The other key factor for us is civil society involvement. And in the truth commissions, what we're finding is those commissions that had testimony of victims were much more likely to include the names of companies than those that did not. And so we have to do more digging on this, but we think that that's how this is emerging in the Truth Commission reports, through the testimonies of individuals. And also in the courts, without there being demand for justice for corporate complicity, we wouldn't find the institutional innovators working for justice for groups of victims. We can come back and talk about that more if you'd like. In terms of what we're thinking about, the value of this is that right now the Truth Commission, our study shows how many Truth Commissions have presented this issue as a kind of restorative justice, at least naming names of companies, but it's still invisible overall. Maybe if we can get some of our work published, we just submitted a manuscript a couple weeks ago for publication, we can start to make this visible, more visible. And it is one way to use transitional justice mechanisms to get at those root causes of concentration of wealth, concentration of power, and impunity that comes with that concentration of wealth and power. So we'd say that the follow-up is really thinking about making this part more consciously part of transitional justice mechanisms. This might bother Pablo, since it might be more concept stretching that or mandate stretching that he's opposed to. But because it's one of the ways that transitional justice could get at root causes, we're thinking that it should be included more. And we also think it's a way to get at not just truth, but also justice and reparations, since many of these cases come with civil claims for individuals or settlements, and then holding these economic actors accountable for their role in this process is a way to start to establish that guarantee of non-repetition. Thank you very much.
Okay, thank you very much, and thank you for those of you who submitted questions. There were a couple of questions that were directly related to the presentation Lee just gave, so maybe Lee, if you can answer while it's fresh on everyone's mind. So one question was, judicial action includes civil cases for money damages, right? Do you care to comment on that? Or maybe define when you refer to judicial action in your research, does that include civil cases for money damages, or how do you define that?
It includes civil cases and criminal cases. So I went through the slides really fast, but if you look at them, it's broken down in terms of, I can bring it back up if you like. We thought when we began to do the project that we were having more success in civil cases and that this seemed to be a pathway to get reparations for victims. But we're actually seeing more criminal action than civil action, and we're not seeing one as more successful than the other. Neither of them are very successful so far. But I'll pull it up so you can look at it longer.
Great, thank you. So there was also a question that related to the Otto Porras Moleno case, Tito Arias case. The question relates to why he's being tried only for financial crimes and not for his role as a regional military commander. Does anyone have a response?
What's the name?
I don't understand the question.
Okay.
Otto Perez Molina. Why is Otto Perez Molina, Tito Arias, being tried only for financial crimes and not for his role as a regional military commander in the Ixil region? ¿Entendiste? Te lo traduzco.
Otto Pérez Molina era un director de inteligencia, pero realmente viene de operaciones, y él lo que hizo fue ejecutar el plan Sofía, que era un plan operativo de un plan de operaciones en los años 80. La CICIG lo que está haciendo es que a partir de una denuncia, y lo que todos nosotros sabíamos era todo el tema de que estas estructuras de inteligencia lo que tenían era control sobre ciertos puestos, dijéramos, o ciertos lugares que eran estratégicos para la inteligencia. En cuenta eran las aduanas, obviamente, ¿verdad? Y de ahí la defraudación aduanera. Por ejemplo, en el caso de Mirna, ya desde los años 90, el teniente Jerez, que hoy es un testigo también en el caso de Pérez Molina por la defraudación aduanera, Ya desde los años 90, los dineros que salían para pagarle al ejército y sobornar a los jueces venía de la defraudación aduanera. Por eso es que nosotros decimos que la impunidad del pasado es la impunidad del presente. Entonces vemos cómo estos actores, que aunque ahora es como ¿cómo se llamaba el mafioso de aquí, de Estados Unidos? Al Capone, que no lo agarran por contrabando, pero te voy a agarrar por defraudación monetaria, pues un poco esa fue la lógica con el caso de la CICIG. No los puedes agarrar por violaciones a derechos humanos porque hay todo un pacto de impunidad, bueno, lo vas a agarrar por algo. Entonces, lo que algo no soporta, y por eso la gente se siente, esta parte de la justicia es más sentida por los guatemaltecos, es porque tú sí estás viendo que todo lo que ya sabíamos se está concretando. Un proceso penal tiene un componente educativo, y lo que ha hecho la CICIG a través de estos casos emblemáticos de corrupción es mostrarte todo el mapa de la cooptación del Estado contra insurgente que hoy es corrupto y además vinculado con el crimen organizado. Y lo que no soportan estas estructuras es el name and shame, ¿verdad? Porque ellos, empresarios honorables, ¿verdad? Que yo tengo mi fortuna, pero soy honorable, y de repente sale que has hecho el dinero a base de corrupción, de violaciones a los derechos humanos. Eso no lo puedo tolerar. Entonces, mientras sean políticos, mientras sean militares, está bien. No sea que sean empresarios, ¿verdad? Porque ahí ya viene el prestigio. Pero lo que sucedió igualmente con Pinochet, ¿verdad? Mientras matan la gente, no es el problema. El problema es cuando ya te tocan el dinero. Entonces, aquí es donde otra vez vemos, ¿verdad?, cuáles son los valores que tenemos como sociedad. Por eso es que muchas veces el tema de justicia, yo digo, también es perversa. Porque no es la vida a la que les importa, sino que es el dinero. No te importa la condición de la gente, sino que te importa cómo es mi. Entonces, todo va relacionado con un tema de dignidad y tiene que ver con la dignidad de la sociedad. Y esa es la lucha que tienen. Por eso es que la justicia legal no es toda la justicia. Y el tema de reparaciones tampoco lo es todo, ¿me entendés? Porque utilizan la parte económica o la parte civil para decirte, ya ven, las víctimas lo que quieren es dinero, no quieren justicia. O lo que quieren, sí, lo que quieren es venganza. Tú lo que tenés es una revictimización y una criminalización. Yo, por ejemplo, te puedo decir que yo perdí a todas mis amistades porque fui criminalizada y sigo siendo criminalizada, ¿verdad? Por la búsqueda de la justicia. Y eso es lo que le pasa a las víctimas. Entonces, por eso nuevamente vuelvo a decir, ¿qué queremos entender por esto? Si luego estos instrumentos de justicia transicional, yo por ejemplo, después de que la Comisión de Esclarecimiento Histórico dio todavía me emociono, pero dio su informe, el impacto de la verdad fue tan grande que, bueno, hasta el día de hoy, cuántos años después, todavía me emociona. Porque nunca vas a poder tener esa oportunidad otra vez de tener una verdad en un marco mucho más integral que la justicia como sistema, porque la justicia como sistema te vuelve a victimizar. Entonces no importa que Otto Pérez Molina esté siendo enjuiciado por defraudación aduanera y por corrupción o por violación a los derechos humanos, responsable de haber ejecutado la Operación Sofía, por ejemplo. Fue una discusión muy fuerte con las organizaciones de derechos humanos, por ejemplo, porque me decían, es que estás traicionando los principios de derechos humanos. Decían, no es la traición, son los mismos actores con distintos delitos. Si no los agarrás por uno, fue el principio de Al Capone, no los agarrás por contrabando, lo agarrás por defraudación fiscal. En el caso de las violaciones a los derechos humanos va a ser exactamente los mismos que se oponen hoy y que están nombrando non grato al comisionado Iván Velázquez, son los mismos actores del conflicto armado interno, los empresarios que colaboraron, que llevaron sus avionetas, que financiaron, que dieron y pasaron listas de sindicalistas, listas de líderes sociales, los mismos directores de inteligencia y del ejército, principales violadores de los derechos humanos, y los mismos políticos que hoy también ellos eran comisionados militares, eran orejas, como le decíamos, o sea, son los mismos actores. Ahí es donde estos instrumentos de justicia transicional no logran cambiar este sistema ni los actores. Y con Mincho en El Salvador siempre decíamos, yo siempre les reclamaba, ¿por qué en El Salvador fue más importante, tuvo más impacto que en el caso de Guatemala? En El Salvador, aunque fue muy operativo los acuerdos de paz, hubo depuración del ejército, hubo depuración del sistema judicial. En el caso de Guatemala no, porque no hubo vinculación. Y el informe de la Comisión de la Verdad ni siquiera lo recibió el presidente de Guatemala estando presente, sino que lo recibe el ministro de Relaciones Exteriores. Solo tú desde ahí ya ves que no había una intención realmente de llegar a una reconciliación. Por eso es que el tema de, dijéramos, bueno, de reconciliación o conciliación, como querramos llamarlo, también se vuelve una utopía, mientras esas transformaciones de fondo o las recomendaciones a las que se llegan y no se operativizan, pues no tiene ningún sentido más que una revictimización.
Thank you. So let's move to a couple of questions on accountability. I'll read them both, and then you can all respond to them. So one question was, what are the problems with holding criminal trials much later, 40 years after a crime? And should these problems affect the sentencing? And then the second question relates to universal jurisdiction. What are your thoughts on universal jurisdiction in light of the Spanish case and the murders of Jesuits in El Salvador? Then maybe you could explain universal jurisdiction for the audience.
Okay, let me just start there.
Yeah.
Universal jurisdiction basically means that for some very serious crimes, states are entitled, it's not obligatory, but it's a permissive norm that allows them to open up their own courts to try crimes committed in other countries and not against their citizens or perpetrated by their own citizens. In other words, crimes committed elsewhere by persons who are not part of the state that is the forum, in this case, the forum state. The most important case, of course, is Pinochet, where the Spanish courts requested the extradition of Pinochet from Britain for crimes committed in Chile against Chilean citizens and by Chilean agents. It has been given a big boost lately with the conviction in Senegal of the dictator of Chad, Hissène Habré. And it's a big boost not only because African states can also use their courts for universal jurisdiction, but because we take away some of this criticism about colonialism and legal imperialism. Nevertheless, first, countries don't have to do this. Second, they face all kinds of difficulties, especially when they try to prosecute very powerful foreign leaders. And since nobody has really the keys to the gate to open these courts, they are, of course, subject to lots of political pressure. But the most important thing that they do accomplish is to generate the conditions for the crimes to be prosecuted in the place where, in the state where they were committed, because that is the obligation. That is a firm affirmative obligation of the state to prosecute them, and the Pinochet case had that effect in Chile. Kath Collins and others have studied that effect. The Pinochet effect, as Naomi Rota-Riasa calls it, it also helped open up the cases in Argentina. So if they have that effect, then that's positive. We should never think that universal jurisdiction substitutes completely for what happens in the state where the violations were committed, because that takes the criminals that are still governing the state, as Helen was saying, off the hook. I mean, they don't like to be subject of arrest warrants in Spain or in Belgium, but they can live with that. So just don't go to those places, and that's it. If the effect is, to reopen the possibility of justice in the country where the violations were committed, that is something that has to be attempted. The first question was?
So what are the problems with holding criminal trials many years after?
Well, of course, it's very preferable to hold them as soon as possible. I mean, there's no question that waiting a long time means that you lose witnesses, you lose documentation. In the meantime, the potential defendants build up their defenses and find ways of countering. They also rely more on political forces. But the one thing that is important to note is that if they cannot happen in real time or as soon after the events as possible, the fact that they can still happen 40 years later is a positive. It's very important because it shows that the legitimate demands for justice by the victims don't go away, and that societies don't forget, and that if you can't prosecute now, you'll find the ways to prosecute later. And that, I think, is the most important lesson of the Southern Cone, where we're still trying cases that happened 40 years ago. And yes, there are difficulties, but those, especially evidentiary difficulties, but it's important not to try to overcome them by cutting corners and violating fair trial and due process guarantees. And again, the 400, 500 convicted military men in Argentina show they all got fair trials. It's not true that they were convicted on bad evidence. They were able to contradict the evidence at every step of the way. They used all their appeal rights, and they're serving time. So it's not impossible to try them later. It does require a lot of, evidence digging, evidence gathering, and preservation of evidence. But it also requires that victims have the courage to come forward, maybe tell their stories over and over and over again. But fortunately, the lesson is that courage is there, that victims will contribute to these efforts whenever they have a chance to do it. Sorry if I went too long on that.
Thank you.
I just wanted to add a couple of other, I would disagree with everything Juan said about the value of holding trials, even if it has to be 40 years later. But there are ways to continue making this a legal process, and one is the statute of limitations. That even though there might be a statute of limitations because of crimes against humanity, those are not valid. But also disappearances, because disappearances, until the person is found, the crime is ongoing, right? And so that makes it still possible to bring these cases. But a serious impediment is that people die. And we find this in some of the cases that we're looking at. Martinez Eos, who was an owner of a company in Argentina and who was then the Minister of Economy, was being held accountable for an on-site detention center at his firm, and he died before he was put on trial. And we also have, if we think about the slave labor cases after the Holocaust, one of the reasons why these slave reparations were pushed through and consolidated and settled is that many of those who had been slave laborers, this is in the 1990s in U.S. courts, were dying. Right? And so to bring justice in their lifetime, it meant taking the cases to court, but it is a problem when you do revisit these cases so long after the fact.
Right, and I'll just add from our experience working with the Cambodians, that is a situation where justice took many decades, and several of the defendants have died or become incapacitated due to age. But one of the interesting things we found was that, maybe not surprisingly, the testimony at the Mock War Crimes Tribunal was very detailed and very rich, because it was taken closer in time. And so that suggests that there's a value, even if there's not an official process, that there is an attempt to document close in time and give the victims the opportunity to share their stories. As a second piece of it, I think, is related to the fact that in doing this project, we were able to re-interview more than half of those who participated initially in the mock war crimes tribunal, but we interviewed another 15 or so individuals who had never told their story. And so they had been carrying, these were people that now in their 70s and 80s who had never talked about the human rights abuses that they experienced in the 1975 to 80 time period, and who now had when they received a copy of their testimony, they were able to share it with their children. And so we heard back from the families that this was
En este caso,
a powerful thing. For one thing, that the elder had been carrying these stories and unable to share them, but now had a way to share them without having to, sit down and tell them in person. But then it generated the opportunity to then talk about what happened. So I just wanted to share those. So another question relates to the CICIG specifically. What is the mandate of the CICIG? Is it an anti-corruption system or one that seeks to dismantle networks of corruption, criminality, human rights violations? Yes. So what is the mandate of the CICIG? Mm-hmm. What is the mandate? Mm-hmm. Right.
The last part of the question.
Well, so is it an anti-corruption system, or is it going farther to dismantle networks of corruption, criminality, human rights violations?
Solo quería comentar antes de entrar al tema de la CICIG, quizás uno de lo que las víctimas nos sentimos o que es liberador en el tema de justicia es cuando tú estás en un juicio y tener la oportunidad de ver cara a cara a tu victimario. Esa parte en donde estás en igualdad de condiciones es la parte más liberadora de un juicio, aunque después que uno cree que la vida le va a cambiar porque has conseguido de alguna medida satisfacción, la vida no te cambia. Entonces volvés otra vez al estado de frustración. Solamente quería decir eso, pero estar en un tribunal cara a cara, frente a frente, y poderle decir y mirarle a los ojos, usted hizo esto, o que cuando se está leyendo la sindicación, porque usted, Edgar Augusto Godor Gaitán, fue responsable en tal fecha, y empieza toda, eso es la parte reparadora y liberadora, por ejemplo, para una víctima, aunque después su vida pues ya no cambia en nada. El mandato de la CICIG realmente en el Acuerdo Global de Derechos Humanos, y esto, de ahí fue donde nosotros nos basamos, fue que en el Acuerdo Global de Derechos Humanos firmado en el año 94 habla sobre la desarticulación de los cuerpos ilegales de aparatos clandestinos. Estos cuerpos ilegales de aparatos clandestinos de seguridad no eran nada más y nada menos que los escuadrones de la muerte, pero dijéramos, estas estructuras contrainsurgentes, lo que van teniendo, por lo que yo explicaba, en estos lugares estratégicos, eran lugares también que se convirtieron en lugares de corrupción. Y es ahí donde empezamos a ver cómo estas estructuras de inteligencia, estas estructuras contrainsurgentes, iban transformándose y teniendo contacto con el crimen organizado. La experiencia de tener un poder judicial cooptado, lo que nos permitía a nosotros era decir, no podemos, y después de la Comisión de Esclarecimiento Histórico, en donde no había una total independencia, lo que nos hacía a nosotros era hacer una propuesta de una fiscalía que fuera totalmente independiente, interna y externamente. Y entonces se estableció el mandato, que era la desestructuración de las estructuras de los cuerpos ilegales de aparatos clandestinos, que es un concepto mucho más amplio, que están ahora en casos de corrupción, por eso la impunidad del pasado, la impunidad del presente. Luego la propuesta de políticas públicas, que tiene que ver con la parte más legislativa, y obviamente, y la otra es el mandato de hacer propuestas y cambios a la ley para ir haciendo transformaciones en las instituciones. Son tres cosas muy concretas que la CICIG puede hacer, y obviamente al investigar un delito te van saliendo pues toda esa red Lee empezaba a hablar, cómo a través de un caso de fraudación aduanera te vincula con diputados que te hacen leyes para favorecerse a ellos mismos, pero al mismo tiempo favorecen a un sector económico, muchas veces empresas, involucrados también en la época del mismo conflicto. ¿Y dónde están los militares? Ahí es donde tú ves. Y después, bueno, ahorita ya se ha complejizado más y por lo que ahora el sector privado es posible hacerle el name and shame porque el área civil era controlada por el sector económico, es que hoy estos cuerpos ilegales de apartos clandestinos que eran los escuadrones de la muerte involucrados ahora también en carteles de droga, se han independizado de lo que es el sector económico. Entonces, el sector económico ya no tiene tanto control sobre un poder político que también nos hace independientes. Y eso hace que hoy estos estados de instituciones débiles se conviertan en una anarquía. Entonces, el concepto de Estado no es un Estado que sea para el servicio o como tradicionalmente está conceptualizado, sino que un Estado que sirve para favorecer intereses del crimen organizado, de la corrupción o globalizado, dijéramos, ¿verdad?, para otros intereses. Entonces, las violaciones a los derechos humanos continúan, pero de una manera distinta. Los escuadrones de la muerte continúan de una manera distinta. Lo que ha cambiado es su forma de operación. Entonces, el mandato de la CICI, que aunque pareciera amplio, es específico al mismo tiempo, que hoy el tema de corrupción es el que se convierte en la problemática de América Latina y creo que de otros países.
Thank you. So a couple of questions related to truth, history, and memory. So one question is this: is the truth represented in the Historical Clarification Commission taught in Guatemalan schools? And the second question is, how do you think Guatemala will be able to continue with fulfilling the obligation to find truth as memory becomes history with new generations and as the political actors in government and civil society?
Yo sigo sosteniendo que la paz en Guatemala no se hizo porque realmente querían detener el genocidio. Se hizo por una conveniencia económica, ¿verdad?, que era el cambio de un modelo económico. Entonces, la narrativa de la Comisión de Esclarecimiento Histórico no les interesó. Y por eso no se volvió una ley que tenía que cambiar. La historia de Guatemala oficial termina en el año 44. No tenemos más historia contemporánea y si tú estudias solo lo ves en una página. Pero es porque hay una narrativa de los contrainsurgentes de no querer dar a conocer pues esa verdad para que no haya repetición. Y la otra pregunta se refería a...
¿Quieres saber si en las escuelas están enseñando?
No, eso es lo que ya dije, que no están enseñando el conflicto.
The other question is how do you think Guatemala will be able to continue fulfilling the obligation to find truth as the generations change, as the young people come up who don't have the same memory of the experience?
A mí me parece que lo que por lo menos a nivel personal me da más esperanza fue el caso de genocidio. Yo creo que el caso de genocidio, como dicen, volvió a polarizar Guatemala, pero hubo una generación nueva que empezó a investigar por sus propios medios, que es la generación que nace con los acuerdos de paz, con un pensamiento crítico y empieza a estar convencido de que sí hay una historia en Guatemala, que no es la historia que te cuentan en los colegios. Ese pensamiento crítico que surge a partir del caso de genocidio, empieza a ser la semilla para luego, en el 2015, que se dan los casos de corrupción de estos mismos contrainsurgentes, hace que salgamos a la plaza, ¿verdad? Entonces, el tema de memoria y el tema de verdad en Guatemala se ha hecho porque las víctimas quieren, no porque el Estado haya puesto un centavo. Ni siquiera en el caso del programa de reparaciones, el Programa Nacional de Reconciliación, de reparaciones, fueron 300 millones que nunca se utilizaron y que cuando salió el programa de víctimas, inmediatamente viene la contrapropuesta de que las patrullas de autodefensa civil también son víctimas y que hay que pagarles. Entonces, realmente voluntad política para preservar la memoria y la verdad y la justicia no hay. Hay una narrativa que sigue insistiendo hasta el día de hoy, incluso en casos de corrupción, que lo que existió es una conspiración de la izquierda otra vez para incluso casos de corrupción o como no llegamos a la revolución y no llegamos al poder, ese es el nuevo intento. Entonces, por eso los instrumentos de justicia transicional, ¿hasta dónde realmente llegan a ser un verdadero? Esa es la pregunta, ¿no?
I would add that we continue to remember the Holocaust. It's not just embedded in history, and this is a lot older in that sense. But one of the ways in which that happens is having a group of mobilized civil society actors who are thinking of ways of informing a new generation and keeping that memory alive. And specifically in the area that we're studying, we're finding very, very interesting civil society campaigns when there's a sense that justice is closed off because of the impunity of businesses. There have been these campaigns in South Africa, for example, timed with key moments like this, the World Cup, where they made posters with the picture of the Mercedes star, saying the star that brought you apartheid, because Mercedes was also supporting the German players in it. So taking advantage of certain kinds of movement, of moments, historical moments, to reawaken memory and to make it real for people. I think what we're going to see today with the films, that's your job, right? To keep it something very much alive, and the visual production of memory is one way to keep it alive, as well as this civil society campaigns.
The question seems to assume that as the victims die off, then memory becomes history. It's the words that are used, and likely, I don't think that that's right. That societal memories are transferred from generation to generation, sometimes better and sometimes less effectively. But as also Helen was saying, it's new generations of Guatemalans who are, pushing for justice and making memory be alive and not history. So I don't have an answer of how it has to be done in Guatemala, but I think what we heard this morning and today, especially from Helen, shows that Guatemalans are finding the way themselves. I think one big problem is that the transition in Guatemala seems to have been from conflict to some kind of peace, but not a transition to democracy in real terms. In the Southern Cone, at least the transition brought forth immediately new actors and new actors willing to teach things in schools, for example. But even there, the pushback, the resistance from people who benefited from the crimes of the past doesn't go away. So let's not have any illusion that the bad guys will accept that they were the bad guys. They will never accept that. The new generations are going to have to relitigate these things, but fortunately they will have to do it with a set of undeniable truths, as Priscilla Hayners calls her book, or the fact that there's a basis, in fact, that's well established, well rigorously analyzed and exposed, that you can deny, but at your peril, that you can't really, you can have whatever interpretation of history you want, but there's a baseline of fact that will not go away. And you know, obviously it's our role to disseminate and to continue pushing for implementation of recommendations. But that's the legacy of a good Truth Commission report like the one in Guatemala. It'll continue to help Guatemalans for a long, long time.
Okay, thank you. Well, we got through almost all of the questions. I apologize if we didn't get to yours, but please join me in thanking our panelists.